Hello everyone and honorable greetings to our doctor. I'm Kadri Ganesan, my metric number 279525. Would like to continue our case study discussion to next question. Therefore, the summary background of facts for case given in perspective of types of facilities and securities. The first facility's goal was to help fund the procurement of specialized machinery and equipment for the borrower's proposal to produce ductile iron pipes and associated fittings. Therefore, the interest payment of Rs 40,000 per month and can capitalize of interest paid during the grace period will become effective for October 1st, 2010. Principal of RC must be repaid within 5 months of the date of each distribution or be due on demand. The interest on any principal money for the time being secure, including capitalized interest, must be capitalized and added to the principal sum owed at the end of each month if unpaid, and shall thus carry interest at the rate indicated. As a condition for the borrowers being extended the second facility, two joint and several guarantee agreements both dated 15 December 2010 were executed by the defendants respectively in favor of PD1 and LNS 1969 Legal Network Series 7 signed a memorandum of deposit of shares dated 15 December 2010 in favor of P. The borrower caused the first and second facility to be arrears in the respective amount as of 31st January 2017. Following that, P's lawyer issued a notice of termination to the borrowers on 16 May 2017, terminating both facilities with immediate effect and demanding payment of the whole outstanding amount within 14 days of the notification date. Concurrent with the foregoing notice of termination, a similar demand dated 16 May 2017 was issued against both defendants who were the borrower's guarantors. The borrower and the defendants failed to meet the request outlined in the letter. Instead of arguing or appealing the termination notice, the borrower's attorney tried to get P's approval to stay all legal action against the borrowers in a letter dated 17 March 2017. That's all from me. Thank you.
Hello, I am Sugashni Kalidasan, my matrix number 280376. Today I am going to present the answer for question 2, which is what were the issues raised by defendants. The defendant's initial complaint was that the plaintiff had not adequately demonstrated the principles, methods of calculation and effective cost of fund rate in the notice of demand on 10th March 2017 and the notice of termination on 16th May 2017 to the borrower. There are no legal or security paperwork requirements for the plaintiff, according to the defendant's assertion regarding the effective cost of fund rate, calculating process and guiding principles. The stated yearly rate of effective cost of fund is 6.75%. The 6.75% annual rate, which is regarded as the plaintiff's base lending rate, is comparable to the plaintiff's stated effective cost of fund rate. However, the rate for the defendants is 6.15% annually. Additionally, there are connections between the borrower and the security documents related to the first and second facilities. Therefore, based on this, the defendants have no right to contest the provisions of the TL facility agreement on 23rd May 2007 between the plaintiff and the borrower. So, the defendants believe that the plaintiff should be held liable for the additional securities he owned in the third and the fourth issues. In addition, the plaintiff has appointed a receiver and manager but hasn't fully divested itself of the securities it owns. The plaintiff also cannot bring this claim against the defendants according to the defendants. So the conclusion is that there is no pertinent justification for judging the defendant's arguments trial-worthy. Thank you.
Hi and Assalamualaikum. My name is Muhammad Firdaus Muhammad Halan. My metric number is 287168. So next we move on to the question number 3. Does the plaintiff have the right to enforce the guarantee provided by defendant due to the loan facility being in default? So my answer, the guarantee agreement and local laws will determine whether the Bank Pembangunan Malaysia Berhad (BPMB) can enforce the defendant's guarantee due to a loan facility default. The defendant's promise will influence these decisions. The BPMB's legal authority to operate in this will be examined. If the borrower, Ibu Kota Realty, fails on the loan, the defendant have pledged to reimburse it. If the defendants did not guarantee the lending facility, they did not agree to repay the debt. This applies whether or not the defendants defaulted on the debt. BPMB may pursue guarantee enforcement if the financing facility defaults. BPMB can enforce the assurance if it can. This power is only utilized when the financing facility defaults. In most cases, the guarantee's legal interpretations and specific provisions will determine its implementations. The agreement specifies the guarantee enforceabilities and terms. This variable includes default events, notice obligations, and judicial claim. Finally, BPMB has the power to enforce the defendant's guarantee. All evidence lead to these conclusions. The guarantee agreement required to the defendants to fulfill Ibu Kota Realty Sdn Bhd obligations if they default. If the borrower fails to refund the lending facility, the BPMB might pursue the defendant to fulfill their guarantee responsibilities. However, the guarantee's enforceability may depend on the agreement's terms and jurisdiction's law. That's all from me.
So now I will continue the presentation for the next question. So the specific detail of the case as well as the rules and regulations that apply will determine whether a defendant has the right to oppose a plaintiff's claim when the plaintiff neglected to notify the defendant of rate change. Generally, when parties enter into a contract or agreement, they are bound by the terms of that contract or agreement. So the defendant may argue that they were not aware of the change and did not give their consent to them, and therefore the plaintiff claim is invalid. However, it may be stated that the defendant should have been aware of the change and that the plaintiff is not responsible for alerting the defendant if the contract or agreement does not specifically state that the plaintiff is responsible for informing the defendant of rate change. So the action of the parties engaged is governed by legal and regulatory requirements. In addition to the contractual duties, the jurisdiction in which the issue is being handled will determine the rules and regulations that apply. For example, some laws may impose a duty of good faith, which requires the parties to act in good faith towards each other. If the plaintiff has acted in bad faith, such as by withholding information about the change in rate risk in order to gain an unfair advantage, the defendant may have the right to contest the claim. Besides that, the defendant may have the right to contest the claim if the plaintiff has acted in bad faith. So that's all from me. I will pass to the next presenter. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Alif Haikal bin Roslan. My matrix number 279039. I will explain the question number 5. Explain the type of guarantee for dependent 1 and dependent 2 and their liability as a principal debtor. A bank will guarantee to fulfill a payment or contract the obligation to the bank guarantee beneficiary or behalf of the corporation to function the manner comparable to the security deposit keep with the different bank. Bank typically impose a fee based on the sum with a minimum RM50. After the contract has been completed or when full payment has been made, the bank return the money it has on deposit for the company. If the banker is unable to execute the term of the contract, the bank will make the payment on the banker's behalf to the beneficiary. If performance bonds demonstrate the dependent eligibility to take part of contract provided, Bank Pembangunan Malaysia Berhad will give bank guarantee to dependent 1 and dependent 2. So to successfully finish the contract, a generator need a performance bond on the one first short guarantee is a performance bond, and bond issued by the bank of the ensure the performance of the certain contract. And performance bond also guarantee the defendant complete the task as a plan to required by the contract in the event that the defendant don't make a repair during the shortfall period. Next, we go to the advance payment guarantee that used to ensure the payment will made to the company carrying out the project when the commercial contract is obtained. If the supplier fail to provide the agree open service or good, the customer will receive a return regarding the advance payment guarantee. First, facility is instead entered to fund a portion of the borrower project to produce the ductile iron pipes and associated fitting by purchasing certain machinery and equipment. According to the case study environment, in addition, the cost of the TNB power substation, new plant machinery and equipment, and construct raw material were largely covered by process from second facility. The defendant must comply with the following requirement set forth in the contract. In individual or organization is in charge of paying back a loan or line of credit given to them to their facility as a principal debtor. That means before purchasing any guarantee made by dependent 1 and 2, the lender will first pursue repayment from the principal debtor. The loan or credit agreement normally specifies the principal debtor obligation, which may include the entire amount of the loan or credit, any interest and fees, and any other term and condition. Any default of the loan agreement should also have effect on the liability of the principal debtor. The principal debtor responsibility could grow. The lender may be able to find a lawsuit to recoup the debt if they don't make a payment or otherwise default on the loan or credit. The obligation of dependent 1 and 2 as guarantee may be active, such as circumstance to sign a loan or credit arrangement. The principal debtor must recognize and accept the responsibility. To make sure they can return the loan as a promise, they should be informed of all of terms and conditions of the loan, including the repayment schedule, interest rate, and any fees. So that's all from me. Thank you.